My name is John Farrell, and I'm an attorney in Marietta, Georgia, and the author of Estate Planning for the Modern Family. Estate Planning for the Modern Family is a step-by-step guide to estate planning here in Georgia, and it is over 140 pages of great resources to help you with your estate planning. But this video is about estate planning made easy, and it's going to give you some of the first things that you need to do in order to make your estate planning easy. And so the first thing that you are going to want to do is to define your estate planning goals. It's a good idea to begin by identifying exactly what it is that you want to accomplish. Now, of course, you want to make sure that your property and your assets are properly distributed upon your passing, but this can mean several things. Dying without a will in Georgia means that the state decides the distribution regardless of your wishes or perhaps your loved one's needs. In Georgia, we call this dying intestate. So while dying intestate is certainly one way to distribute your assets, it's certainly not the best way. It's usually better to make sure that your legacy goes to those that you choose for yourself. So start asking yourself a few questions. For example, do you want to choose who will raise your minor children? Do you want to put aside protection for your adult special needs child? Do you want to ensure your business enters the right hands if you become disabled or die? Are you interested in minimizing estate taxes and court fees and legal expenses? And is there a group or charity that you wish to support upon your passing? And these are some of the things that may be very important to you, and you can refer to this list as you plan your estate, as you answer those types of questions. So the first thing you want to do is certainly define your estate planning goals. Now, the second thing that you want to do is list your assets. Now, this step can seem fairly straightforward. You want to list the things of value that will be left behind once you become incapacitated or pass away. This list may include things like your home or other real estate that you may have, investments, pension plans, things like insurance policies even, checking accounts and savings accounts, and valuable collectibles that you may have. Something included as well as personal effects, all those non-titled things in your home like art and china and even sofas. Anything else that you can think of. Now, working with an experienced Georgia estate planning and probate lawyer can also help you brainstorm assets that you may not think of yourself. And these are things like photos on Facebook or digital music, things of that nature you may not necessarily see as something that's part of your estate, but it certainly is. So the third step in this process is to choose your beneficiaries. And what you want to do is just list the individuals in your life who you want to receive a portion of your estate upon your passing. Beneficiaries may be individuals like your spouse and children, but they could also be people like your parents or nieces and nephews. And they can also be things like corporations or nonprofit organizations like the American Red Cross or things of that nature. Now, note that some beneficiaries may already be designated through other instruments. For example, if you have a life insurance policy that requires you to designate a beneficiary, then it will typically just bypass the probate process in general. So certain things like life insurance policies and certain investment accounts, retirement accounts, 401ks, things of that nature that require you to designate a beneficiary will typically bypass the probate process and go to those people. But you certainly want to decide who you want to receive your estate upon your passing. So once you have those three things together, the next thing that you want to do is to prepare a last will and testament. That is one of the most basic estate planning instruments out there. Other estate planning instruments may be better for you, and that's why it's good to talk with an experienced estate planning attorney. Things like trusts, those are certainly very popular these days and may be more appropriate for you. But regardless of who you are, whether you are rich or poor, young or old, everyone can benefit from having a last will and testament in place. And it's one of the biggest mistakes that you can make and could really have lasting consequences if you do not have a last will and testament in place. I think there has been surveys done where they say that at least half the people in Georgia do not have a will in place, and it's startling to think that even some parents will leave, more instructions to a babysitter when they're going to be gone for one night than they will leave for their family when they're going to be gone for a lifetime and won't be able to call home to check in. And we often hear these stories when it comes to celebrities, but fact is that no matter how wealthy or poor you are, young or old, everyone should at least have a last will and testament in place. And a last will and testament is a legal document where a person, they are typically known as the testator, state their wishes and desires as to the disposition of their property following their death. Now, this is not to be confused with a living will, which is an advanced directive for health care that people use when they're still alive. The last will and testament is used following someone's passing rather than before their passing with the health care power of attorney. A properly arranged will can do lots of things for you. It can name a guardian that you choose for your children. Can leave specific instructions on how you want your assets divided. It can choose who is the executor for the estate, who the person is that's going to be dividing everything up. It can give you assurance that your possessions, your assets are going to go to the people that you want them to go to, and it can even create trust for any minor children that you have. And so the last thing you want to do in this process is to make sure that you get a last will and testament in place. And you'll want to consult with a Georgia will and estate planning attorney when drafting your will. One of the nice things about the will is that you are able to modify it at any time as long as you're mentally competent and able to do so. And you can change it if you have something like a change in your family or financial or other circumstances. And so those are generally the 4 steps in the process to make sure that your estate planning is made easy. First, define your estate planning goals. Second, list your assets. 3, choose your beneficiaries. And for 4, prepare your last will and testament. And so hopefully this has been helpful to you and will get you started. If there's anything that we can do to assist you, please feel free to reach out to us and we'll be glad to assist you.